We now move to questions to the Minister of Justice, and I call Mr. Harry Harvey.
Question 1, please.
Minister.
The Prisons 25 by 25 Strategic Improvement Programme captures the Prison Service's ambition for continued development and improvement. The focus of the programme is delivering the best possible service to those in our care and for wider society. Year 2 concluded at the end of March. Achievements included 3 recruitment campaigns, further development of support services for serving and former staff, the launch of a substance misuse strategy, the completion of over 100 minor works projects and the rollout of X-ray body scanners in all 3 prisons. The programme has now entered its 3rd and final year. While it is right that the planned actions continue to be ambitious, it's important to acknowledge the context the Prison Service will be operating and delivering within, with a significantly increased and increasing prison population.
Mr. Harvey.
Okay. Thank the Minister for your answer. Maybe the Minister could update the House on the development of the programme to facilitate autism-friendly visits as part of the Strengthening Family Relations Strategy.
Minister.
Well, I thank the member for the opportunity to do so. A number of years ago, when I visited the prisons, one of our staff had very helpfully designed a programme to support children with autism or indeed neurodiversity to be able to access prison visits better than had been the case in the past. As people will appreciate, family connections are a hugely important part of the rehabilitation process. They're also a hugely important part of the prisoner's life during the time when they're apart from their family, and conversely for their family while they're apart from the prisoner. And so a lot is at stake when those visits go well or do not go well. Autism and autism spectrum disorders can lead people to find the prison environment very stressful and lead to a degradation in the quality of visits. And so that programme was put in place to particularly support those individuals who were neurodiverse, acquaint them with the processes that they would face when they arrived at prison, acquaint them with the different stages of search and with the environment. Obviously, those who have particular sensory issues will find prison often a stressful environment. The noise, the sniffer dogs, the change of environment can be quite stressful. And so preparing particularly children but also adult visitors for what to expect when they arrive at the prison has proven to be very valuable to families. Also recognising that some of our prisoners also now arrive with quite complex needs, often with undiagnosed neurodiversity issues. And so one of the things we're looking at is how we better support those prisoners too on their journey through the system so that they get the maximum benefit from their time in our custody. Thank you.
Mr. Speaker, I thank the Minister. The Prisons 25 by 25 is important. One of the key issues is our people, and you're absolutely right in that. So can I ask the Minister, are new prison officer recruits security cleared before they have access to the prison system on the landings?
Minister.
The operational detail of that is something that I would advise the member to raise with the Director General. However, no one would have access to security level information unless they have been adequately cleared in order to take up that role. Checks are made before people are allocated to the various roles that they play within the system, and therefore I would imagine it would be the same with prison.
Kate Nicholl.
Mr. Speaker, thank the Minister for her answers so far. Can I ask what the impact of rising population is having on prisons, numbers in prisons?
Well, our experience shows us, and evidence demonstrates, that a high prison population generally results in an increase in tension within the prison setting. Managing prisoners in terms of encouraging positive behaviour becomes more challenging, for example, leading to increases in assaults and incidents. When we're dealing with a more volatile environment, that leads to increases in the use of force, the number of adjudications and the use of segregation. And that can contribute to prisoners, particularly vulnerable prisoners, feeling more unsafe, and levels of self-harm tend to increase. Prisoners in general are cooperative when they are treated with humanity and respect. In essence, when relationships between them and the prison staff are positive and courteous. And therefore, it's hugely important that NIP seeks to maintain appropriate living conditions, out of cell time, and the delivery of a predictable and stable regime. If NIPs don't have sufficient staff available each day, it isn't possible to offer that predictability, and therefore restrictions will increase, out-of-cell time will reduce, and relationships with staff deteriorate. The fact that over 500 prisoners are now doubling up across the estate also has an impact on living conditions and both prisoner and staff morale.
Hold on, McMurray.
Question 2.
Minister.
The harms that are most commonly associated with paramilitary gangs are centred around drugs, violence against the person, public order issues and bombing and shooting attacks. What is less obvious is how gangs groom, exploit and harm vulnerable young people to maintain their position in communities through intimidation and the threat of violence. To help highlight this, the Executive Programme on Paramilitarism and Organised Crime produced 3 short case study videos covering the topics of violence, victims and child criminal exploitation. The first film launched on the 1st of May and has been viewed over 46,000 times on social media, prompting media and public discussion. The remaining 2 videos in the series that cover the topics of violence and criminal exploitation will be launched by the programme in August and September, respectively.
Mr. McMurray.
Thank you, Mr. Speaker, and thank you, Minister. Will the videos be used in education settings?
The hope is that these videos will serve as a prompt for discussion and learning to be used by EPOC's delivery partners, engaging with different groups of service users as well as with all schools. It can be integrated into existing programmes such as those by the Education Authority, Communities in Transition, Developing Women in the Community, Aspire, Engage, NIACRO and others. And the plan is that the videos can serve as a prompt for people who may not realise themselves or indeed their friends to have been subject, for example, to child criminal exploitation, but on watching the videos and on looking at the evidence that's presented in those videos may recognise themselves or others as victims and therefore be more willing to report and make disclosure about this abuse.
Matthew O'Toole.
Thank you, Mr. Speaker. Question 3.
Minister.
My department has had some limited engagement to date with the Independent Commission for Reconciliation and Information Recovery, which was formally established on the 1st of May. The Commissioner for Investigations, Peter Sheridan, wrote to me in March to update me on the development of the Commission and its operating model. In his letter, he offered to meet with me to brief me more fully on these matters, and that meeting took place on the 4th of June. The Commission has also requested a meeting with my officials, which is due to take place next month. The Northern Ireland Troubles Legacy and Reconciliation Act 2023 places statutory duties on relevant authorities, including the PSNI, the Office of the Police Ombudsman for Northern Ireland, to provide such information, documents and material as the Commission may reasonably require to enable it to carry out reviews of deaths and other harmful contact during the period of the Troubles. I'm aware the Commission has been engaging directly with these organisations on how those interfaces will be managed. There has also been some preliminary engagement with Forensic Science Northern Ireland and with the Legacy Inquest units within the Northern Ireland Courts and Tribunal Service. My opposition to the legislation passed in Westminster and my concerns as to the impact it will have, both on the right of victims and survivors to access justice and also to wider public confidence in the justice system, remain. The justice organisations for which my department has responsibility will nevertheless fully comply with any obligations now placed on them by the Act and will not seek to obstruct or frustrate in any way the delivery of truth or justice to those impacted most directly by the Troubles.
Mr. O'Toole.
Thank you, Mr. Speaker. Minister, I acknowledge that there are legal obligations placed on your departments and its bodies by the bill, and it would be wrong to obstruct them. But isn't it also the case that, given every party in this chamber opposes this bill, that it would be right now for your officials to plan on the basis for that bill to be repealed, as is the policy of what will be hopefully the incoming UK government? Do you agree with that, and will you instruct your officials to plan and prepare for that eventuality?
Minister.
Well, I'm already committed to the issue of repeal of the legislation, and I've been very clear that I believe that that is what should happen. I think we have to look in the round at what has been suggested by Labour Party statements. Whilst Sir Keir Starmer has pledged to repeal the Act if there is a Labour government following a general election on the 4th of July, in speaking on Good Morning Ulster, the shadow Northern Ireland Secretary Hilary Benn said Labour would remove immunity from the Act and restore civil cases and inquests. So that would appear to be something of a dichotomy in terms of the approach of Labour. My department will make preparations for whichever outcome government announce in due course, and in the interim will abide by our legal requirements in terms of cooperation.
John Bunting.
The Minister will be aware that not everybody is willing to engage with these new bodies, and some innocent victims and their families have trust issues around the new arrangements. What reassurance can she give those families that they and their cases will not be left behind?
Well, I deeply regret the fact that I can give such people no consolation in this, because this matter is out with the competence of my department and of this Assembly. Responsibility for legislation around legacy has been taken by the Westminster Government. They have made their decision that this is the way forward. I have consistently made my opposition to the Act clear and fully support calls for it to be repealed. I hope whoever is in government following the general election will make that a priority and listen to victims and survivors and support them in their quest for both truth and justice. However, I cannot offer them an alternative means of seeking truth and justice, which has been barred by legislation from Westminster.
Stuart Dixon.
Thank you, Minister. Minister, while this piece of legislation remains in place, can you tell us what funding the department is expected to receive in order to service the legislation?
Minister.
Well, one of the great challenges that we have had is being able to determine what burden it will place on the legislation in terms of the new arrangements. So whilst government is clear that they believe that it will alleviate some of the pressures that have previously faced the department in handling these issues, there has been no allowance, for example, for some of the requests that have been made to be funded in addition to what we received through the block grant, and I can think of a number of examples where that is the case. I, however, have been very clear to all of the organisations that work and are funded by the Department of Justice that any work done for the ICRIR is a separate line of accounting. It needs to be treated as such, and it needs to be recovered from the UK Government. Treasury rules are clear that whoever owns the policy pays the bill, and that has to apply in this case.
Paula Bradshaw.
Question number 4, please.
Minister.
I've been very clear about my commitment to raising the minimum age of criminal responsibility in Northern Ireland in order to bring us closer to meeting international standards, including those set by the UN Committee on the Rights of the Child. At 10 years of age, our current MACR is the lowest in Europe. In raising it, we are not saying that children's offending behaviour should be ignored, but they should not face the full force of the justice system. In order to seek the views of the public on this important issue, I agreed to a consultation which was carried out in 2022. It showed overwhelming support for an increase in MACR, with over 83% of respondents agreeing that the age should be increased beyond 10 years. The majority of these supported an increase to 14 years. Based on the outcome of the consultation, my officials have developed an options paper, and I intend to share this with my executive colleagues to seek their views on my proposals. As any increase in the minimum age of criminal responsibility requires legislative change, it will not be possible for me to progress it in the absence of executive approval.
Paula Bradshaw.
Speaker, and thank you, Minister. Minister, could you please outline what would be the effect of increasing the minimum age? Thank you.
Minister.
The effect will depend much on the agreed new minimum age, but it would only affect very limited numbers of individuals, as very few young children are currently dealt with through the formal justice system, thanks to the work of the Youth Justice Agency. So, for example, if MACR was raised to 12, it would have affected a total of 63 children in 2022, as this was a number dealt with through court or diversionary measures. Only 12 of these were prosecuted at court, which was less than 1% of the total number of children dealt with in that year. Some may see that as a reason not to make a change, but as well as meeting our international obligations, raising the minimum age of criminal responsibility sends out, I believe, a very clear message that young children who offend need support, guidance and help, not criminalisation and punishment. Were MACR raised, it would be our intention to work with partners across other statutory, voluntary and community sectors to agree a framework through which children engaging in criminal or antisocial behaviour could receive multi-agency support in the community to address their behaviour and underlying issues. We know that contact, particularly early contact with the justice system, tends not to augur well for people's long-term life outcomes. The longer we can keep our young people out of the justice system and provide them with the support they need, the better for everyone in society.
Colm McGrath.
Question number 5, Mr. Speaker.
As I publicly stated to this House on the 4th of June, I am not ruling out future action and stand ready and willing to support the Board in such actions as considered necessary. However, at this stage, I remain satisfied that no action on my part is yet required, as the processes of accountability by the Chief Constable, the Policing Board, the Investigatory Powers Tribunal and the McCulloch Review should be allowed to conclude without interference.
Mr McGrath.
Thank you very much, Mr Speaker. Just in the interest of clarity, could the Minister then confirm that there is no rule or law preventing the calling of an independent inquiry now, that is a decision that the Minister is taking?
It is a decision taken in line with the guidance in the legislation. It's clear that it says that a minister, in making a decision to call a public inquiry, must have due regard to what other investigatory mechanisms are available to deal with an issue before proceeding. It is also the case that it would be improper, though not impossible, to cut across what is a tribunal system which is judge-led. I have also set out the other restrictions that may come into play at such times as I would be directly asked to institute an inquiry, in that these issues may well interface with the security services, in which case my powers as a devolved minister, and indeed any devolved minister's powers, are significantly constrained by the 2005 Inquiry Act.
John Blair.
Mr Speaker, following up to that question, Mr Speaker, does the Minister agree that all mechanisms available to the Policing Board should be exhausted in such circumstances before any inquiry should be considered? Those are the matters around the policing arrangement that are precious and important to the accountability of the Chief Constable to the Policing Board.
Minister.
I think it's a very important point. I mean, the Chief Constable is ultimately operationally responsible to the Policing Board. Those patent arrangements were put in place after a considerable amount of thought and with a considerable amount of sensitivity. And I would be loath as Justice Minister to take a wrecking ball to the delicate balances therein. That course of action, obviously, and how the Policing Board decide to proceed in terms of their investigations is a matter for the Board. I respect their operational independence in their role of holding the Chief Constable to account. However, I understand that the Board has agreed to exercise its power under Section 59 of the Police Northern Ireland Act 2000 to require the Chief Constable to submit a further report on the matter, and that provided the terms of reference for the McCulloch Review meet the Board's Section 59 requirements, then it will act as their Section 59 report.
Linda Dillon.
Thank the Minister. Question number 6.
Minister.
Until the 4 recommendations outlined in the Northern Ireland Audit Office report relating to the Police Injury on Duty scheme are addressed, I have no plans to remove either the injury on duty or ill health retirement responsibilities from the Northern Ireland Policing Board at this stage. The matter is out for a targeted consultation until the 17th of July 2024. However, the roles and responsibilities of the Department, PSNI and the Policing Board will be considered as part of those future deliberations.
Still.
Thank you, Minister. Thank you for your response. So, can you confirm then, based on the responses to that consultation, might you again revisit this and consider bringing forward legislation in order on the ill health retirement and injury on duty? We certainly don't want a system where we have 2 separate processes either, because you could have one officer going through 2 separate processes.
Minister.
Well, I understand the point that's being made, but given the roles and responsibilities of the Board were established by the Patent Report, any change is likely to be a cross-cutting matter involving Executive Office and the Department of Finance, and potentially requiring an amendment to both primary and secondary legislation. So it would be important, before making any commitment to change, that we have done the proper consideration on this. In March 2020, obviously, the Northern Ireland Audit Office concluded its report into injury on duty schemes for officers and looked at injury on duty awards made to former police and prison officers for injuries sustained while they were on duty. One recommendation of the report was to set up a steering group comprised of key representatives from DOJ, DOF, the Police Service, the Board and the Northern Ireland Prison Service and the Departmental Solicitor's Office to manage the implementation of the recommendations. And those 2 subgroups now report to the steering group were established to allow us to take this forward. The steering group is considering the roles and responsibilities associated with the PSNI injury on duty scheme to determine where they would be best placed. However, I think it's important that we do not cut across other important work which is also strictly time bound and needs to be taken forward in shorter measure when we come to look at this particular issue.
Donny Donnelly.
Thank you, Mr Speaker. Just to ask the Minister what she has done to try to address the backlog in IMR appointments.
Minister.
The issue of IMR is a significant one. We have now engaged the service of an external supplier, which has allowed the independent medical referee assessment process to commence on the 4th of March this year. Officials have instructed the supplier to procure additional resources with a view to resolving the backlog as soon as possible. That backlog is a result of medical appointments being paused due to several factors. They include the COVID pandemic, by removing the ability for cases to be actioned, the MacLeod remedy requiring the reassessment of some police pensions, the expiration of the department's last IMR contract, and difficulty in procuring a new supplier who could provide the services. Thankfully, on that last score, we now have that arrangement in place.
Trevor Clark.
Thank the Minister for answers thus far. Minister, will you accept that the current process for ill health retirement and injury and duty is clunky and not fit for purpose? And would you also accept, given the high numbers of people involved in it and the low numbers of police officers actually in the front line, that we need a robust system fast to resolve those issues for many of those officers who will never be able to return to work are off in excess of 12 months? So would you accept that we need to do something more swiftly rather than some forms of consultations?
Minister.
Well, there is, of course, nothing to stop the board doing whatever it wishes to speed up the injury on duty scheme in terms of its delivery. That is the responsibility of the board, and it is not for me to direct the board how to implement that scheme or what resources to attach to it. The question that's been asked of me is whether or not I would relocate that injury on duty responsibility either in the department or more likely with the Chief Constable. And that is a question that I think we need to approach with due care and attention. We're waiting on a consultation outcome in July, and when we have that consultation outcome and have been able to see the feedback on that, we can then look to whether or not this is the way to proceed. Because we do need to make sure that we don't simply move a failing scheme potentially around different organisations. We need to get to the bottom of why the delays have happened and how we eliminate those delays, rather than do things that simply may make life easier, I guarantee you, for the board, but may not actually help the officers you speak about.
Alan Chambers. Minister.
In September 2021, my department established the multi-agency review arrangements known as MARA to assess and manage risks posed by terrorist risk offenders. This is in line with Article 50 of the Criminal Justice Northern Ireland Order 2008, which makes provision for the management of offenders who may cause serious harm to the public. In discharging this function, MARA brings together the Department of Justice and supervising officers appointed on the department's behalf, along with representatives from the Northern Ireland Prison Service and the Police Service of Northern Ireland. Terrorist risk offenders are managed under MARA from the point of conviction through to the expiry of their licence period. Within the arrangements, supervising officers work with partners to conduct risk assessments, prepare risk management plans, provide reports for reviews by the Parole Commissioners for Northern Ireland, and monitor those offenders who have been released into the community. Those arrangements enhance and support public protection.
Mr. Chambers.
Thank you, Minister. Can the Minister outline the annual cost to her department of His Majesty's Prisons and Probation Services?
Minister.
The Department has allocated around £500,000 for the 24-25 year to support the deployment of supervising officers whose role it is to engage with TROs to support the assessment and management of their risk. The funding secures supervision officers and administrative staff, 6.5 full-time equivalent, from HMPPS. The supervising officers are all qualified probation officers. My priority is keeping the public safe and delivering effective public protection. It can be a costly exercise, but savings are realised wherever possible.
Peter Ferguson.
Thank you, Mr. Speaker. Question number 8.
Minister.
I recognise the very important contribution already being made by the Commissioner-designate for Victims of Crime in giving a voice to victims and representing their needs and interests. I plan to introduce legislation before the end of the mandate to put the role of Commissioner for Victims of Crime on a statutory footing.
Ms. Ferguson.
Thank you, Mr. Speaker. And Mr. Speaker, would you allow me just to put on record my thanks to Skeig Community Hub and the ladies and gentlemen from Skeig and Derry who have come along here today to find out more about the work of ourselves in the Assembly. I would just like to ask the Minister, what steps have you taken to ensure the role of the Victims of Crime Commissioner Designate is fully functioning before it's put on a statutory footing?
Well, the Commissioner-designate in her office continue to represent the needs, rights and interests of all victims of crime. I'm very grateful for the level of engagement with victims and families that the Commissioner-designate and her team have taken forward, and for her identification of priority areas for change. And indeed, she has not only been instrumental in amplifying the voices of victims of crime to promote better service delivery and compliance with the Victims' Charter, but she has also, I think, been critical in terms of driving up protection for victim data and privacy. In that regard, I also hope that in the next number of weeks and on a trial basis, she will be joining us at the Criminal Justice Board, so that as we make decisions about crucial issues such as speeding up justice, she will have a seat at the table.
Anna Egan.
Thank you, Mr. Speaker, and thank you, Minister, for your answers so far. Can I please ask, Minister, what is your assessment of the impact of the work of the Commissioner-designate so far?
Minister.
I think the work that the Commissioner-designate has done is hugely important. As members will be aware, at the time when we appointed a Commissioner, the idea was that that person would lead on areas such as hate crime and particularly domestic violence and abuse. Her work in that regard has been extremely strong, and indeed she has not only challenged around the legislation and the Victims' Charter and the areas there, but has also looked very carefully at the flow from domestic abuse cases into the family courts and challenged for reform in terms of the family court system, which I think has been incredibly helpful, particularly to those victims who I think we have all engaged, who find that sometimes the family court system can be abused by former partners in order to try to coerce and control them post the point of breakup. I think her voice on this, her independence on this is hugely important, and the challenge function that she can provide at the moment is powerful, but I believe that on a statutory footing she will be able to do much more.
Dara Hunter.
Thank you. Question 9, please, Minister.
Sir.
I'm planning a range of reforms which will add to the supports for rape victims, such as the establishment of remote evidence centres, advocacy and sexual offences legal advisors that my department has already introduced. These new measures include legislation to provide greater regulation of the use of victims' private information within the criminal justice disclosure process, and to clarify when and how pre-trial third-party representation for victims of serious offences may be enabled. These measures will support victims who wish to object to applications for disclosure of their personal information, such as medical or counselling records, or to admit evidence at trial of their previous sexual history. Subject to funding, I also hope to launch a pilot to test pre-recorded cross-examination before the end of this mandate and to establish SOLAs for child victims. I look forward to receiving reports from ongoing research into attrition in serious sexual offence cases and will use the findings to develop further measures to increase victims' confidence to report sexual crime and to remain in the criminal justice system to the conclusion of their cases.
Ms. Hunter.
Thank you, Mr. Speaker. Minister, recently I met with a fantastic sexual offences legal advisory team who do incredible work supporting rape victims in Northern Ireland, and they have said that there is no mandatory policy by which the PPS is notified about a rape case. Is this something that you could make mandatory within this mandate? And also, I welcome the news that you're looking at providing a SOLA for under 18s. Do you have a timeline on this? And that would be great. Thank you.
Well, with respect to the first, I would be interested in meeting with the member to discuss that further. It's not an issue that has been specifically raised with me through the department, but it is something that I would be keen to address if there is a gap in provision. In terms of the CSOLA, we had hoped to be able to do that this year, but we did not get the resource that we had bid for that project. So we will continue through the work that's being done with the under 13s pilot and now hopefully extending that to under 16s to expedite those cases through the justice system, to give as much support as we can and to then continue to work with others to try to secure the additional funding that would be needed for the CSOLA.
Dear McReynolds.
The Minister for her responses so far. Can the Minister outline what support is currently in place to support rape victims at trial?
There are a range of supports that are available in terms of people who go to trial in rape cases. One of them, I think, is particularly that people have the right to seek special measures, which means that they don't have to come to the court and give their evidence in public. Some of the review reforms that were proposed by Sir John Gillen's review have been implemented and are having a very positive effect. Obviously, disclosure is one of the areas that we would wish to address because we believe that there are issues around disclosure that have been negative. The secretive use of victims' third-party material has also been a concern for victims' rights and advocates. We also ensure that victims are informed of the SOLA service and can self-refer to legal advice prior to making a report. Finally, the provision of remote evidence centres is hugely important in terms of ensuring that victims can give their evidence in a safe and comfortable surrounding away from the court building. We have excluded the general public from the courtroom at trial, and we continue to implement other Gillen recommendations to reduce delay, improve training for frontline staff who deal with victims, improve achieving best evidence procedures and disclosure processes to help the experiences of victims and sexual crime. However, the most powerful thing we can do as an Assembly is not the things that we do to support those who are victims of crime. It is the things that we do to change our society so people are less at risk of becoming victims of crime. And so I look forward to seeing the strategy for ending violence against women and girls being published soon in order that we can refocus on preventing victims being created rather than simply the supports that we can offer people once their lives have been often irretrievably destroyed.
Matthew O'Toole, move to topical questions.
Thank you, Mr. Speaker. Minister, should you be successful in seeking office to leave the office you hold now, this could be the last time you're in this chamber as Minister answering questions. You've now had several weeks to consider whether to appeal the High Court's scathing rejection of the anonymity provisions in the Justice Sexual Offences and Trafficking of Victims Act. Can I ask, will you do what sexual offence victims and media organisations would like you to do and confirm that you will not appeal that judgment?
Minister.
I will do what is right in front of the law and in front of this Assembly. The specifics of the sexual offences and trafficking victims, the 4 clauses, are one element of that consideration and an important one. But the wider ramifications of the judgment for the ability of this House and Assembly committees to be able to take forward legislation, and indeed for the Executive to be able to do so, are not insignificant. And therefore I will wait until I have had the full legal advice offered to me before I make any decision. I have briefed my Executive colleagues and others for whom this is relevant already on some of the detail of that, and I will make the right decision based on the future of this House and its ability to legislate on these matters.
Mr. O'Toole.
Given your standing for election to leave the job in a fortnight's time, Minister, you may not be the one who makes that decision. I know your diary is filled with visits to fun fairs and other matters, but it is important that we deal with these things seriously. Another issue is political stability. You and I agree that neither the First or Deputy First Minister should have the power to resign their offices and throw the Executive into instability. If you are successfully elected as MP for East Belfast, your replacement will have to be elected specifically and uniquely via the members of this chamber. Will you commit that if that happens, first of all, is there a political agreement that will be an Alliance Party representative who replaces you? And if there isn't an agreement that an Alliance Party representative will replace you in that election, will you commit that your party will not throw the institutions into instability by leaving the Executive, should the next Justice Minister, if you are successful in the general election, be an Alliance representative?
Minister.
With respect, Mr. Speaker, I'm not sure that the general election is a matter that falls to the Department of Justice, nor do I believe it's particularly appropriate. I can't use my resources in the department to promote my campaign. Equally, I don't think that other parties ought to be using this chamber to promote theirs. I think there has to be some appropriateness when it comes to these things. But I am glad to know that the member is watching me so closely in terms of how I spent my time outside the chamber. He will no doubt have also recognised that the 30 seconds I spent on the ghost train, which by the way was excellent value for money, was only a tiny part of a busy day spent on the campaign trail.
Dr. Aiken's not in his place. I call Paula Bradshaw.
Speaker. Minister, could you please give us an update on your plan? Sorry, wrong page. Minister, could you please give us an update on the implementation of the Post Office Horizon System Offences Act 2024? Thank you.
Sure.
Thank you. My department is currently working with the UK Government and with operational partners in implementation of the Act. This includes identifying any cases within scope of the legislation, notifying the individuals concerned and ensuring their records are updated. This work is ongoing. Although the number of cases that have been identified in Northern Ireland is relatively small, the hurt and distress the Horizon scandal inflicted on the individuals concerned is no less significant. I am therefore keen to ensure that all those who have had convictions overturned or cautions deleted are notified as soon as possible, and that those eligible to receive financial redress should be allowed to access that as swiftly as possible also.
Ms Bradshaw.
Thank you, Mr Speaker, and thank you, Minister. I think you've touched upon it a bit there. However, could you please give us an indication of how quickly those people who are affected will know that their conviction has been overturned? Thank you.
Prior to the calling of the election, it was anticipated that this bill would be approved and receive royal assent in early to mid-July. And so that is the deadline to which my department was working. However, the Act has now gone through those processes very swiftly in the wash-up in Westminster, and therefore we are notifying people that their convictions have been quashed, where that conviction has been identified, and take steps to notify a personal representative if that person is deceased, as I've described in my original answer. Our original intent was that those letters would issue within the scope of the legislation at the point of royal assent. However, now that that has moved forward to the 24th of May, that has not been possible. However, work to identify individuals within scope of legislation is very advanced. Indeed, I received an update from the Chief Constable this morning on that issue. And once that assessment of cases has been completed, we will issue those letters without any delay. The intention is for letters to issue to affected individuals in advance of the opening of the financial redress scheme for the cohort of applicants, which we understand from the Department for Business and Trade is provisionally scheduled for the end of July. However, if anyone believes that they have the right to be exonerated under this scheme, I would encourage them, even at this stage, to come forward to the Department, make us aware of your case and allow us to find the relevant information to ensure that everyone who is entitled to support is fully captured.
Call Morris Bradley.
Speaker, to ask the Minister, is the good news that funding is available for the necessary upgrade at Her Majesty's Prison in Magilligan. However, following reductions in the budget, how will this reduction impact on the actual work due to take place at the correctional facility?
Minister.
Well, as the member knows, we remain absolutely committed to a replacement facility being built in Magilligan. Initially, the plan was that we would move forward on the basis of both the residential and the kitchen and dining accommodation to move forward as a single project. Due to the restrictions, both in terms of resources in the department and particularly in terms of the capital budget, and the urgency of the work required in terms of the kitchen and the dining facilities, we have decided instead to split those into two separate business cases. We will advance the kitchen and dining facilities first, and then we will submit a business case at a later stage to advance the accommodation element of this, because we believe that the kitchen is the bit of the facility that is at most risk given the age of the facility and the need for upgrade.
Mr Bradley.
Thank you, Deputy Speaker. Thank you very much for your answer, Minister. Minister, I raised this question quite some time ago, almost 6 years ago, to a previous Justice Minister. And here we are, the same question arises again. Is there a time frame set aside for work to commence on the actual prison itself?
Minister.
Well, I want again to reassure the member, work has commenced in terms of the design process, in terms of the business case process, and all of the preliminaries that need to be done. However, we cannot start to cut sod on these two major pieces of the jigsaw until such times as we know we have the resources to do so. But he also knows, and I know he visits the prison to check on progress, he will know that there has been other significant development around Magilligan. So there have been improvements, for example, to power lines, there have been improvements to the exterior, there have been improvements to the House of Worship and a number of other spaces within the prison that are very significant. And we will continue to make those moderate adaptations to the system in the meantime. But those major projects ultimately are entirely reliant on availability of capital investment, for which I am competing with schools, with hospitals and with all of the other public sector. And very often people do not realise just how important it is that we do rebuild our prison system and provide a safe and dignified environment, not only for the people who live there, but the people who work there.
Call Padraig Delargy.
For her answer so far. Minister, I would appreciate if you could give me an update on any involvement that your department has had in supporting initiatives which are run particularly as we approach the summer season across my constituency in Derry by community and voluntary organisations, particularly those which aim to minimise anti-community behaviour.
I won't pretend that I can run through every single scheme that the department is involved in, but we do have a relatively small footprint in terms of the work that we do. However, the Youth Justice Agency is engaged in a number of diversionary programmes, particularly dealing with young people. The ARCS recovery scheme is also used to invest in community-based organisations who themselves are providing facilities. And if the member would like, I can provide him with some further detail in terms of within his own constituency what organisations we're funding on those issues.
Mr. DeLargay.
Yeah, I would definitely appreciate that, thank you. And could you also provide me with an update on any cross-departmental work that you're doing along, particularly with the Executive Office?
Minister.
Well, there are a number of things, including, for example, the Communities in Transition Scheme. There are a number of areas where we work with TEO, but also we work with the Department for Communities around diversionary activity and trying to support young people particularly, but also wider communities in terms of building resilience against paramilitary and organised crime, which we know can be a genuine issue for many people. It was also remiss of me not to mention, Mr. Speaker, that obviously the PCSPs in each of the councils are funded by my department and also invest in local projects and diversionary schemes in order to support the wider work of the PSNI and the other law enforcement agencies and their community and voluntary sector partners.
Peter McReynolds.
Thank the Minister for his responses so far. Will you join with me, Minister, in condemning the so-called show of strength by the UBF in East Belfast at the weekend?
Minister.
I would love to say I have pleasure in doing so, but I have no pleasure in doing so. I think it is incredibly disturbing that at this juncture in Northern Ireland we continue to see such shows of strength. I think the people of Northern Ireland generally and of East Belfast in particular are weary of these paramilitary organisations exerting coercive control in their community. They're not interested in changes in leadership and management. They're interested in these organisations being put out of business. The sooner that happens, I think the better for us all.
Mr. McReynolds.
I thank the Minister for her response and certainly agree with the sentiment of her answer. Minister, do you agree with me that what took place on Saturday evening demonstrates the coercive control such organisations exert over our communities and that discussions around group transition are no longer appropriate in 2024?
Well, I think the obvious thing that most of us can see is that many groups have very successfully transitioned with no government support. They've now transitioned fully into organised crime gangs. So where they want to make a change, a step change in function, they seem capable of doing it without any support from anywhere else. From my perspective, I don't believe that group transition, in the sense that these organisations will become post-conflict organisations, is the answer. I believe individuals need to transition back to law-abiding members of our community. They need to integrate into society on the same basis as the rest of us and cease the coercive control and the threat and intimidation that they wield. Some people refer to these as shows of strength, Mr. Speaker. In my view, they are shows of fragility. When you have to ship people in from outside to cause intimidation in a constituency, there's nothing strong about that.
John Blair.
Mr. Speaker, the Gillen Review was mentioned in an earlier reply, and given the wide-ranging but very important issues associated with that review, could the Minister give an update on the progress her department is making on the Gillen Review?
Minister.
Well, I remain fully committed to the full implementation of the Gillen Review. It is a transformational programme, but it requires a collaborative approach across other ministerial departments, statutory agencies and third sector organisations. Some work streams, for example, such as those related to relationship and sex education, fall to the Minister of Education to progress. We have made good progress. 76% of recommendations have been implemented to some degree, 62% fully completed, further 14% are partially completed, and that's usually in the form of a pilot. Whilst it's useful to note the number of completed recommendations, it's equally important to note the measures and services introduced as part of the implementation programme that are making a real life difference to victims. Access to free legal advice, which we discussed earlier in response to Ms Cara Hunter's answer, is hugely important to people. Many are now able to give evidence from remote evidence centres away from court and are therefore much likely to attend their court hearings and not be intimidated away from doing so. Members of the public can no longer be in a courtroom during a trial. Complainants are no longer required to give oral evidence at a committal hearing, forcing them to give evidence about the most traumatic moment in their life twice. And across the criminal justice system, professionals have better access to training so they can understand and deal sensitively with the trauma the complainants have suffered. I think it's hugely important that we continue with that work.
Mr. Blair.
Mr. Speaker, I think the Minister has alluded to this already, but to confirm, can the Minister confirm that engagement with stakeholders will continue as recommendations of that review are implemented?
Minister.
We will continue to work not only with our statutory partners, but also with the wider justice system and with the community and voluntary sector. In particular, we're working on the judge-led voluntary protocol. It has been seen a 70% reduction in the average time taken between reporting a sexual offence and court disposal, and that's for child witnesses under 13. It's now being extended, so they're expediting as much as possible similar serious sexual offences involving children under 16 in all divisions of the court. And if there is more that we can do at each stage, whether that's through child solace or whether it's through experiences like this, or indeed the existing NSPCC-led establishment with the remote evidence centres, we will continue to do all in our power to work with partners to deliver the best possible outcomes.
If members take their ease for a moment, we now move to the questions for the Minister for Agriculture, Environment and Rural Affairs. So just while the Ministers change positions.